Welcome to Washington's Legal Foundation's briefing. My name is Glenn Lammi. I am Executive Director and Head of our Legal Studies Division, and we're certainly pleased to have you with us today. I'm going to promote, All right. Just promoting one of our attendees to be one of our speakers. There she is. Okay. So we've been a pretty busy group this term at Washington Legal Foundation, as we typically are. We filed merits level briefs in 8 cases so far. We'll be filing in a 9th case. We'll be discussing today the Laboratory Corporation versus Davis case. Davis is actually one of the 7 granted cases this term where WLF supported the cert petition with an amicus brief, which I think is the most grants we've had during the Roberts Court era for Supreme Court cases where WLF was a supporting amicus, which is really our sort of bread and butter as a litigating group. So we're really excited about that. A lot to talk about today, so let me get started in introducing our panelists. Barbara Tyson Smith is a partner in the St. Louis, Missouri office of Bryan, Leighton, Paisner, LLP, and co-chair of the firm's appellate and Supreme Court group. Barbara has represented clients filing petitions for certiorari, opposing certiorari, and has filed merits briefs as well. She has also represented amici at the certiorari and merit stage levels. She served as a law clerk to Associate Justice Samuel Alito and to U.S. Court of Appeals for the D.C. Circuit Judge Thomas B. Griffith. Barbara also served in the White House counsel's office during George W. Bush's presidency. Luke McCloud is a partner in the Washington, D.C. office of Williams & Connolly. He is an experienced appellate advocate, presenting arguments before the Supreme Court 3 times and in multiple federal courts of appeals. He has served as a law clerk to Associate Justice Sonia Sotomayor, U.S. Court of Appeals for the D.C. Circuit Judge Brett Kavanaugh, and 4th Circuit Judge Paul Niemeyer. In 2023, Luke left the firm to serve as assistant to the Solicitor General at the Department of Justice and returned to the firm last year. Finally, Katherine Yarger is a partner with Lehotsky, Keller, Cohn in Denver, Colorado. She's an experienced litigator focusing on complex commercial litigation at the trial and appellate levels in state and federal courts. Katie previously served as trial and appellate litigator at Gibson, Dunn & Crutcher and Wheel Trego O'Donnell, where she represented clients across a wide array of industry sectors. She served as a law clerk to Associate Justice Clarence Thomas, to Colorado Supreme Court Justice Allison Ide, and to U.S. Court of Appeals for the 10th Circuit Judge Neil M. Gorsuch. Just want to remind everyone that we are recording this webinar. If you have any questions during the program, please use the Q&A function in the Zoom webinar toolbar, and we will get to your question either during the program or towards the end of the program. So I thought we would start out by talking about the few of the court's decisions and decisions not to decide. So Barbara, the court issued a unanimous decision in one of the cases argued on first October and Monday, Royal Canin USA versus Wolfschlager. What did the court hold and how might the holding impact civil litigation?
Yeah, so this Royal Canin case is about so-called prescription dog food, which is dog food that you need a prescription from your vet in order to feed your dog, but which doesn't actually contain any medication. And so the plaintiff in this case alleged they were charging a premium price on the basis of fraudulent advertising because this was really just off-the-shelf dog food marketed as prescription. She filed claims under the Missouri Merchandising Practices Act and state antitrust laws here in Missouri. And she also included in her complaint several federal FDCA-related claims. On the basis of those federal claims, the defendants removed to federal court, as defendants often do in cases like this. The district court proceeded to litigation. Litigation unfolded over the course of 2 years. At the conclusion of that, at the end of those 2 years, there was an amendment to the complaint to drop the federal claims. And the plaintiff alleged that by dropping all of those references to the FDCA, that there was no supplemental jurisdiction over the state law claim and the case should be remanded to state court. That went up to the 8th Circuit, which held that remand was appropriate in a case like this. That created a split among the Court of Appeals. The 8th Circuit was the first and only court to hold that remand is appropriate on a removed case when the federal claims in the case are subsequently dropped in an amended pleading. The Supreme Court heard argument and decided the case unanimously in January, a decision authored by Justice Kagan. And she held that the question whether the court has jurisdiction in removed cases can be affected by an amended pleading. So there's no longer supplemental jurisdiction when a complaint is amended post-removal to drop federal claims and complaints. The impact of this is obviously to make it harder for defendants that want a federal forum in cases like this. They face the prospect of attempting to remove and then facing a plaintiff that just drops references to federal claims in order to get back in state court. That might not be a problem in sort of run-of-the-mill removed cases. This is how the defendants described at oral argument the run-of-the-mill problem. You remove a case, the plaintiffs immediately drop the federal claims, and it gets remanded immediately to state court. There's not a ton of wasted time and resources in that circumstance, although you do lose access to the federal forum. The problem, I think, for defendants with this court's holding is that the facts of this case could repeat themselves in the future. You could have a plaintiff that is removed to federal court, litigates extensively for 2 years, including one interlocutory appeal to the Eighth Circuit, ultimately a decision on the merits where the federal court intended to dismiss the complaint. And then at that late moment in the case, 2 years later, after all of that time and expense has been incurred, there's an amendment that drops the federal claims and you're sent right back to state court. So we might call that a second bite at the apple colloquially, although based on this case, I think you might call it like a second bowl of dog food. But in any event, it results in defendants facing potential additional costs for a removed case that subsequently loses its federal question.
Thanks, Barbara. The court issued another unanimous opinion in EMD Sales versus Carrera, which is a case that Luke's partner, Elisa Blatt, argued successfully for the petitioner. Luke, can you give us a short rundown on this decision?
Yeah, happy to, Glenn. So I think this is actually an interesting counterpoint to the Royal Canin case that Barbara just discussed, because this is another case where you had a single circuit court that had adopted a rule that was different from the rule that was applied by all the other circuits. In this case, the Fourth Circuit had a rule that required employers to demonstrate the applicability of an exception to the Fair Labor Standards Act by clear and convincing evidence, whereas the other circuits applied the usual preponderance of the evidence standard. And the question presented was whether the Fourth Circuit was right to apply that higher standard. It's a fairly narrow issue. And in fact, when the Supreme Court called for the views of the Solicitor General, the United States said the court should either summarily reverse the Fourth Circuit or just deny the petition because it wasn't sufficiently important to warrant the court's attention. But the court granted cert. And as you might have expected from that introduction, the court had no trouble concluding that the Fourth Circuit had been getting it wrong. Justice Kavanaugh wrote a relatively short opinion that explained that preponderance of the evidence is the baseline standard in civil cases, and it applies unless Congress or the Constitution says otherwise, or unless the government is taking away a person's rights in a manner that's similar to a criminal prosecution. And because none of those exceptions applied in this case, the preponderance standard still applied. As I said, I think there's a parallel here with the Royal Canin case. In that case, the court bucked a basically unanimous consensus of the circuits. And here the court reinforced an almost unanimous consensus. And in both cases, it's really just the text of the relevant statutory provision that drove the result. Like in the Royal Canin case, the court was not persuaded in EMD by the various policy arguments that the Fourth Circuit and the respondents had for why they thought the rule made sense. The court looked at the text of the statute, thought that it answered the question, and that was the end of the day. And I think that's a theme that we will see throughout our discussion here today, that the court, as it has been for the past 20 or 30 years, is very focused on statutory text as the starting point and often the ending point of its analysis.
The court decided not to decide two cases that they had oral arguments in that involved the securities laws, separately involving Meta and NVIDIA. WLF had supported the petitions for both certiorari, both cases at the cert stage. So we were happy that they were granted, filed amicus briefs on the merits. So we're kind of disappointed that the court dismissed them as improvidently granted. Luke, what happened here?
Yeah, so I think you're probably not the only folks who are disappointed in the result in this case. And these cases, to me, illustrate another very interesting feature of the modern Supreme Court, which is that the justices seem to have a very firm view of why the court as an institution exists. The justices often write in their opinions that the court does not do error correction. They view their job as resolving important legal questions and coming up with clear legal rules, or at least hopefully clear legal rules that are going to apply in lots of cases going forward. And so I think what happened in the NVIDIA and the Facebook cases is that the court realized after argument that the questions they had been asked to decide were really not as broadly applicable and as clear cut as they first appeared to be. Both NVIDIA and Facebook were cases about the pleading standards under the securities laws. And the plaintiffs in those cases alleged the companies had made various misrepresentations about the risks that their businesses faced. And in both cases, the Ninth Circuit held that the plaintiffs' allegations were sufficient, at least in part. Given the cert grant, it seemed very likely the court was going to reverse the Ninth Circuit and set out a new standard for adjudicating the adequacy of these kinds of risk disclosures in securities cases. But it became clear during both arguments that it would be difficult to draw a sharp line between adequate disclosures and inadequate disclosures. This was especially apparent, I think, during the NVIDIA argument where Neil Katyal, formerly of Hogan Lovells, argued the justices seemed very frustrated that at times NVIDIA was asking the justices to dive into the complaint and say which individual allegations were okay and which weren't. And it was clear that the justices thought that task was beneath them. So it wasn't a huge surprise to see the court issue orders dismissing the cases as improvidently granted. But, Glenn, as you said, I do think it's somewhat disappointing. Even if the petitioners in these cases were just asking for some form of error correction can be important. There can still be value in the court providing guidance on how to apply existing standards to the facts of big, important cases. And the court declined to do that in these cases, and instead we'll have to wait and see if some better vehicle comes along that more cleanly tees up these questions.
The last decided case we're going to look at is the TikTok versus Garland case, where the court fast-tracked both the briefing and its decision. Luke, do you think that the court's decision is going to have any broader implications for the online community beyond the obvious major impact on TikTok's future?
Yeah, so I think, Glenn, the answer is a resounding maybe. On the one hand, the decision does suggest that the government is going to have very broad powers to regulate the operation of foreign companies in the United States, even if those companies are used by a lot of US citizens, and even if those citizens are using the company's product to create what we would normally think of as protected speech. I think that's bound to have some sort of chilling effect on the operations of foreign internet-related companies within the US. And although I am skeptical the Supreme Court would apply the same sort of analysis and accept the same sort of national security justifications as readily when it comes to regulating online speech that's hosted by US companies, I wouldn't rule it out either. So if I'm an internet company, I'm probably concerned about the precedent that this decision sets. On the other hand, just because the Supreme Court says that the government can do something doesn't mean that the politicians will actually go out and do it. And to me, what's most remarkable about the TikTok case is that, as you mentioned, the Supreme Court put in all this effort to expedite briefing and hear the case very quickly and come up with a decision at what was basically lightning speed for the Supreme Court. And then both the Trump administration and the Biden administration decided basically to ignore the divestment law at issue. So it could be that TikTok just ends up being kind of a strange one-off, that even though the Supreme Court seems to have given the government this power, there's not a real interest on the part of the government in using that power. But I think only time will tell whether this decision actually has a lot of significance going forward.
Thank you, Luke. So before we move on to talking about pending oral argument cases, Barbara, Katie, do you have anything you'd like to decide on the cases that we discussed that have already been decided?
Yeah, so the only thing I'll add on the TikTok case, just a couple of quick points. One, as Luke said, this was a lightning speed case. I think it was 7 days between oral argument and when the per curiam decision came down. And if you read Justice Gorsuch's separate concurrence in that case, there's a little bit of, I don't want to call it frustration, but maybe consternation with the speed at which the case was the court was forced to decide that case. I wonder whether that frustration is perhaps shared by other members of the court and reflects a broader frustration with the increased number of emergency motions the court's required to hear on its motions docket, and whether that frustration will somehow transform the docket in one way or the other. Don't think there's any obvious implication there, but it was just a suggestion in his separate concurrence. The other thing I wanted to note about that case is obviously it was unanimous and it went against what the incoming Solicitor General for President Trump had suggested the court do. So if we expect to see other cases challenging Trump administration executive orders or actions, I'd like to hold that in the back of our minds as we hear criticisms of the court being overly political or outcome oriented. This is an example of the opposite of that, a unanimous decision that goes against what the administration had requested.
Katie?
I do think the court went out of its way in TikTok to emphasize the factual nature of the question that it was answering. I think it was heavily influenced by the role of a foreign adversary in the way that it decided that case. And so I would be hesitant to take any sort of broader principles about First Amendment application to tech companies in particular moving forward. I do think that case is narrow. And then returning to the two cases that were dismissed as improvidently granted, I think the court's trend of taking fewer and fewer cases per year and viewing its role as solely non-error correction related, I guess, is maybe the best way to say it, is potentially problematic. I think the number of cases that the court is taking, you're seeing an increase in the number of opinions that are being written, the length of those opinions. And I think it's that old saying that too much time makes mischief. And I think the court could potentially be well served to rethink its role in error correction. Some of these cases, the impact of the individual case on the economy, on the individual company is astronomical, sometimes to the tune of billions of dollars. And for the court to just wave these away as pure error correction, I think is problematic. I think we would also see a potential tightening in the jurisprudence if the court would tighten up its opinions. We don't need 120 plus page opinions in just a handful of cases being written. Well, I guess maybe a handful. That's perhaps a bit of an exaggeration, but we're looking at an era where previously the court was deciding well over 100 cases per year, and now we are far, far below that. So I think it's perhaps an unfortunate development.
Thanks, Katie. So as we go through the cases that are going to be argued in the second half, if any of the speakers to whom I'm not directing the question would like to comment on the case that we're discussing, please don't hesitate to do so. So Katie, this first one's for you, which is one of the most potentially impactful cases in the regulatory space that's not yet been scheduled for argument is FCC versus Consumers Research, which implicates the non-delegation doctrine. Can you talk a bit about that?
Yes, absolutely. So I clerked for two of the justices, I think, who are perhaps the most interested in reviving the non-delegation doctrine. That's Justice Thomas, and then I clerked for then Judge Gorsuch, now Justice Gorsuch. So this case is particularly interesting to me, just given those two justices' individual jurisprudence. So just quick background to understand the case and to frame it here. The amended Telecommunications Act directs the FCC to establish a set of programs known as the Universal Service Fund. So under this fund, carriers that provide interstate telecommunications services must contribute to the fund per the statute and the regulations, which we'll get to in a minute. And the point is really to provide universal service. The Telecommunications Act was meant to, or at least this component of it was meant to address a problem where telecommunication companies wouldn't want to be providing services to rural areas in particular, given the cost. And so it's a form of a subsidy. This fund operates as a subsidy to allow those services to be provided to rural locations at a more, quote, equitable rate. And so the statute directs the commission to use the money in the fund to subsidize universal services, I just indicated, and gives the FCC 6 principles that are supposed to guide and limit its authority. And I'll just list out the principles quickly. Sorry to do so because the language is very dry. But I think before I do so, please keep in mind that the key here is that they don't guide the amount of money that the telecommunications providers are supposed to put into the fund. They don't delineate the bounds of this tax, which is functionally what it is, in any manner whatsoever. And they're not really, when you think about it, guiding principles. They're more aspirational statements. So let me just read them quickly for context. So the statute says that the services should be available at just and reasonable and affordable rates. And this is all to kind of inform how much money is supposed to go into this fund, right? So they're talking about what the services should be. The services should be available at just, reasonable, and affordable rates. The services should be available to all regions of the nation, and that all of these regions should have access to the services. This is the language of the statute, not my words. The customers throughout the nation should have access to services that are reasonably comparable in quality and price. and that carriers should make equitable and non-discriminatory contributions to universal service, and that universal service subsidies should be specific, predictable, and sufficient. So if you're the FCC and you're looking at these, quote, guiding factors, I don't understand how a single one of them, and I'm not alone in this, tells the FCC about what the contributions should in fact be, or even tells the telecommunications providers themselves what the contributions, what the bounds of the contributions will be. And then, of course, this doesn't just stop with the telecommunication providers, because it flows on to the consumers themselves in the form of a tax. And so one additional statutory piece that's important, because the Solicitor General leaned into it, a subsection of the statute also requires that the charges must be paid, quote, into sufficient mechanisms established by the FCC to preserve and advance universal service. And they must be equitable and non-discriminatory. And the Solicitor General argued that this provision itself indicates and provides guidance to the FCC related to the quantum of the contribution to the fund. Governor Newsom described this as having absolutely no, he used the phrase of having, he has absolutely no idea what that means. I happen to agree. And then to top it all off, the FCC isn't actually limited by these 6 principles or the language of Section 254D, because of course it is permitted per the statute to add additional principles to guide contributions to the fund as necessary and appropriate. So it doesn't stop there. The delegation didn't just stop with a Congress's delegation of power to the FCC. The FCC then took its power and redelegated its own authority to a private corporation called the Universal Service Administration Company. It did so even though the statute did not give it the authority to separately delegate to a private entity, and didn't give it, of course, didn't give it any guiding principles of what that private entity would be permitted to do. But functionally, what that entity does is a bunch of math in the background to figure out what the contribution factor should be. So essentially the percentage of the telecommunications company's total revenue should be contributed to the fund. And interestingly enough, in the beginning, it started out at about 4%, and it's now up to 37%. So kind of just runs in one single direction. The government argued that the statute specifies who must pay the universal service contributions, the terms on which they must do so, the purposes, the types of services, and the types of entities that may receive the funding, and that all of these factors were somehow sufficient to cabin the authority granted to the FCC and therefore provided an intelligible principle. And then with regard to the separate secondary delegation to the private entity, the government described that as really a solicitation of advice from the private entity, that the private entity wasn't in fact doing anything regulatory in and of itself, but was just simply providing advice to the FCC. This is, I think, probably belied by the record, given that the FCC just functionally rubber stamps the recommendation for the contribution factor provided by this private entity. And the respondent argued in its response brief that the problem with the real sort of nub of the problem here is that Congress didn't give any contour, any limitation, any specificity related to the amount to be put into the fund, and quoted Hamilton from the Federalist Papers saying that the amount of taxes to be laid is a matter for the legislature, and then quoted Justice Gorsuch as saying that it cannot be left to bureaucrats to fill up, let alone for a multi-billion-dollar social welfare program, which is essentially what this is. And so the problem here is really multifaceted. First, it was a delegation functionally of taxing power. So it wasn't just a delegation of a more general legislative function, but specifically the power to tax. So that's problem number one. Problem number two, it was a delegation without an intelligible principle, if that phrase even has any meaning left to it at all. And then on top of that, it was a delegation to the FCC, and then the FCC then went and delegated further authority to a private entity. Now, again, FCC claimed that it was just an advisory service that this private entity was providing, but the record demonstrates that in fact the FCC was just functionally rubber stamping what this private entity was recommending. So this case could be decided by the Supreme Court in a number of different ways. I think the court did add a QP. I'm not going to get into it here because I think it's too detailed for the amount of time that we have. But the court did add a QP suggesting that it may find an off-ramp here under the mootness doctrine, just given the nature of the way that the challenge was teed up. But setting that aside for a second, assuming that the court doesn't take the jurisdictional off-ramp, I think the court could decide this in a couple of different ways. It could lean into the fact that it's a delegation of taxing authority. It could lean into the fact that this is actually a not intelligible principle. So it could keep the same test in place, the same legal test in place for the delegation, non-delegation doctrine, but find that this runs afoul of it. It could articulate a different test. It could find that the first delegation to the FCC is not problematic, but that the second delegation to the private entity is problematic. Just backing up for a minute, the Fifth Circuit's ultimate decision here found that this ran afoul of the non-delegation doctrine, not because of the delegation to the FCC on its own, or separately because of the delegation to the private entity, but rather that in combination, the two delegations compounded on top of one another violated the non-delegation doctrine. And I think probably the Fifth Circuit did that because it was trying to get out from underneath existing Supreme Court jurisprudence. It was trying to say, probably, that under existing Supreme Court jurisprudence, this would not run afoul of the non-delegation doctrine, but because there's no Supreme Court jurisprudence on what happens when you have two combined delegations in this way, it sort of used that as a way to decide the case and conclude that it ran afoul of the non-delegation doctrine. So really, really important case. Just from a 10,000-foot view, I think this continues the trend of the Supreme Court trying to correct the balance of powers between the different branches of government, very much in the vein of the Loper line of cases and other administrative law cases that we're seeing coming out of the court. So pretty big deal, definitely worth watching. Here's to hoping that the court decides the case and doesn't take the off-ramp. Oh.
Sorry. The court has 3 upcoming arguments in cases where EPA is a party. Do you anticipate, Katie, the change in administration is going to impact how the SG's office presents its arguments in these in any way?
Yes, absolutely. We've seen initially the acting Solicitor General, Sarah Harris, filing motions to the court in at least 2 of these cases, asking that the briefing schedule be held in abeyance. The court has denied those motions, and the pitch there was essentially, please don't decide these. Let us undo these actions through the regulatory process. Court said no. And so the cases are proceeding. And I think the next step now is going to be a pitch from the parties to the Solicitor General, to ask the Solicitor General, the acting Solicitor General, Sarah Harris, to take the side of the petitioners against the EPA. So to essentially flip the EPA's position on the cases. And so I think it's going to be interesting to see how that plays out. So in Diamond Alternative Energy in particular, and that's the case that I'm the most familiar with, the case is one related to redressability, and the court's decision, the DC Circuit's decision in the case, is pretty aggressive. I guess maybe we should say it's pretty aggressive reading of the redressability doctrine as a mechanism for barring those particular petitioners from challenging that underlying law, and we're going to get to that in just a moment. But I think that the petitioners in that case are likely to make a pitch to the Solicitor General that the government should shift its position. And that's not going to create a lot of complexity in that case because there are still interveners. There will still be there'll still be California as a party to litigate the position that the DC Circuit took on redressability, the decision of the DC Circuit on redressability. So I think we're likely to see, at least in that case in particular, shifting of the Solicitor General's position.
So they won't have to have, the court's not going to have to appoint an amicus to represent the government, basically.
Correct. So it won't slow down the current schedule in that case.
So you did mention the Diamond Alternative Energy case, which is one that I'd like you to elaborate on a bit more. Is that, it's a standing case? Is this a kind of run-of-the-mill standing case, or does this have bigger implications?
Well, I think it's just more examples of the DC Circuit monkeying around with standing jurisprudence to prevent or to stop any stop itself from having to make any sort of decision on the merits of these environmental cases in particular. So That case, the way that case is teed up is very interesting. It involves California's Advanced Clean Cars 1. So as folks on this Zoom might know, California has an exception under the Clean Air Act with regard to certain environmental regulations, air quality in particular, for localized pollution needs. And so California has been using this exception under the exception to preemption that it has been granted under the Clean Air Act to functionally regulate greenhouse gas emissions through vehicle regulations. And so the first iteration of this is Advanced Clean Cars 1. And in its simplest form, it's just a ramping up of an EV mandate over time. So I think in this case, it's roughly 25% by 2027 of all new vehicles sold in California must be fully electric. And so the petitioners, who are fuel producers, challenged the case. The car manufacturers, who are the directly regulated entities, did not challenge the case, did not challenge the regulation, did not challenge EPA's grant of a waiver to California under the Clean Air Act to implement its regulations mandating electric vehicles in California, electric vehicle sales in California. And so the car manufacturers sat on the sidelines, and there are some really interesting reasons as to why maybe they did that, but they were not the challengers here, even though they are the directly regulated parties. So the fuel petitioners came in and said, well, in any event, we are affected by these regulations, of course, because that's the whole point of them, is to reduce fuel consumption. And so we're going to go ahead and challenge these. We're going to go ahead and challenge the waiver, the grant of the waiver to California to allow California to regulate here because it diminishes demand for our product. So we are harmed. And the DC Circuit ultimately held, no, it doesn't, because you don't have evidence from the car manufacturers themselves to say how the car manufacturers will respond to the regulation, how they will, adjust their behavior in response to the regulation. They may go ahead and produce this many EVs anyway in the absence of the regulation because of consumer demand, said the DC Circuit. And so the DC Circuit held that because the petitioners in that case, the fuel petitioners, didn't have specific evidence from the directly regulated entities, that they did not have standing as the affected entities to challenge the regulation, to challenge the grant of the waiver. And so they, of course, petitioned to the Supreme Court, and the Supreme Court took the case. Really important because there are many examples across the country across our jurisprudence, as the opening paragraph of the brief points out, where the non-directly regulated party still has standing to challenge the regulation because of the predictable effects of the regulation itself. And in Diamond Alternative Energy, it even went beyond the predictable effects of the regulation because, of course, the fuel petitioners put into evidence through declarations the fact that this would have a significant effect on the demand for their product. So I think pretty important standing case to rectify this sort of offshoot of redressability jurisprudence that's coming out of the DC Circuit. And I think we will see the court go ahead and decide the case, I predict, in the petitioner's favor.
Luke or Barbara, do you have any thoughts on the consumers research case or the Diamond Energy alternative energy case before we move on to non-regulatory areas?
Only that I agree that the non-delegation questions are the cases raising those questions are cases we should pay particular attention to post-Loper-Bright, since that's likely the next generation of challenges to the administrative state. So this is going to have impacts beyond just FCC Universal Service Fund questions.
Yeah, I agree with that. I think that non-delegation, is the next frontier. The court has made a lot of moves on Chevron, or what used to be Chevron doctrine, a lot of moves on non-delegation, and it seems that there is going to be a push, at least by certain members of the court, to fully develop this as a real, meaningful doctrine that's going to apply across a lot of different areas. And so I'm interested to see how far they go and whether they revise the doctrine a little or just a lot.
Thanks, Luke. Katie, anything to mention on the other two EPA-related cases, the non-Diamond alternative energy ones?
Yeah, so Oklahoma versus EPA, I think, is an interesting example of parties trying to get out of the DC Circuit. The DC Circuit just sort of has functionally had the monopoly, via statute and otherwise, over these regulatory challenges in the environmental space in particular. And so in that case, the question is whether or not when EPA makes individual determinations for particular states, right? But it's doing so across a common methodology. But they are state specific, whether or not those challenges can be in a particular locale tethered to where the state is, or whether or not the EPA can rely on the sort of universal methodology and the fact that it's releasing the state-specific regulations at the same time to pull those cases back into the DC Circuit, again, because, of course, EPA perceives that the DC Circuit is going to be a more favorable jurisdiction. And so I think it's going to be very important to see how the court decides that case and whether or not parties are going to have an opportunity to sort of be released from the power of the DC Circuit. You see another example of this sort of creative attempts to get out from underneath the DC Circuit in the petitioner's challenge to the grant of the waiver for Advanced Clean Cars 2. So Advanced Clean Cars 2 is the follow-on to Advanced Clean Cars 1. It's a waiver granted to California that allows California to mandate that 100% of all vehicles sold in California by 2035 are electric. And so petitioners filed a challenge to that waiver that was granted by EPA in the waning days of the Biden administration. They challenged that in the Ninth Circuit instead of the DC Circuit, arguing that really because the exception to the Clean Air Act, well, this will have to be what their argument ultimately is, that because the exception to the Clean Air Act that allows the waiver to be granted to California requires that the effects of the regulation be solely localized, the regulation, therefore, they can't have a nationwide effect and be subject to jurisdiction in the DC Circuit, that it actually does, in fact, properly belong in the Ninth Circuit. Be interesting to see how that one plays out as well. But I just think more examples of parties trying to get out from underneath the DC Circuit's jurisprudence.
Between that case, and I think there was a case argued in the first term involving FDA and tobacco company litigation in the Fifth Circuit as to whether or not the case should be filed in the Fifth Circuit or not. So it's interesting to see the court taking on these so-called venue shopping issues more than once in a term. So on March 4th, the court's going to hear arguments in a case where the nation of Mexico is suing U.S. firearms manufacturer Smith & Wesson. Barbara, because the case involves two broadly applicable concepts in civil justice, is it fair to say that this is much more than your average gun case?
So I think you're right, Glenn, that this is both a case about guns and a case not about guns. Here's what's happening generally. So U.S. firearms manufacturers make guns and they enter the stream of commerce. Some of those end up in the hands of Mexican drug cartels that use those weapons to commit crimes, including against the Mexican government. The Mexican government filed a lawsuit in the District of Massachusetts seeking against the gun manufacturers $10 billion in damages and injunctive relief to change the way in which these companies manufacture and market their firearms. The problem is there's a federal law called the Protection of Lawful Commerce in Arms Act that insulates firearm manufacturers from liability, quote, arising from the criminal or unlawful misuse of firearms by a third party. So the district court dismissed the complaint under that statute, saying it was preempted, but the First Circuit reinstated it based on an exception to the liability protection that allows a suit to proceed if there is a knowing violation by a firearms manufacturer where that violation is the proximate cause of the injury to the plaintiff. So Mexico argued to the First Circuit, and the First Circuit agreed that gun companies unlawfully, and this is their term, aided and abetted the cartel's crimes. Because they had knowledge that some of their products would be trafficked into Mexico and would be used in this way by criminals. And they said that the manufacturers were a proximate cause of Mexico's injuries because the cartel's use of the illegally smuggled guns to commit crimes was reasonably foreseeable to the manufacturers. So taking those facts together, there are two questions presented in this case. The first is whether the production and sale of firearms in the United States is a proximate cause of the alleged injuries to the Mexican government from gun violence committed by cartels in Mexico. And second, whether the production and sale of firearms in the United States amounts to aiding and abetting unlawful firearms trafficking, where companies know that their products will be unlawfully trafficked. So the gun manufacturers, in challenging the proximate cause finding, make the argument, as you might expect, that proximate cause requires a direct relationship between what the defendant does and how the plaintiff is injured. And the way that they describe the causal chain makes clear that they think there are multiple intervening criminal acts that preclude a proximate cause finding here. They describe it as highly attenuated by multiple independent, voluntary, and sometimes criminal acts. Here's how it works. Federally licensed manufacturers sell firearms to federally licensed wholesalers who sell firearms to federally licensed dealers, some of whom negligently or maybe intentionally sell firearms to criminals who traffic guns across the border, some of which end up in the hands of cartels and are used to commit crimes against the Mexican government, for which that government incurs costs and fees and other types of harms. So their argument is that a finding of proximate cause here could expose other industries to significant liability for what they call similar conduct, lawfully putting a good into the stream of commerce that is in a downward stream used by criminals to commit crimes. They also, with respect to the aiding and abetting question, argue that an arm's length commercial transaction in the ordinary course of a lawful business can't aid and abet a criminal act, because aiding and abetting requires both an affirmative act by the defendant and a specific finding of scienter, specific intent that the criminal act occur. Obviously, Mexico argues against both of those things with respect to proximate cause. They say this attenuated chain of causation doesn't matter because it was reasonably foreseeable to the gun manufacturers that the guns would be used in this way. And with respect to aiding and abetting liability, they say that the gun manufacturers are knowingly allowing guns to be sold by what are called by them red flag dealers. Those are dealers that whose sales or whose history of sales of weapons raise red flags, for example, because there are significant volumes to a single person on repeated instances that could suggest, they argue, that that person is a trafficker. And relatedly, they also make the argument with respect to aiding and abetting liability that the gun manufacturers are particularly and specifically marketing certain types of products, that is, certain firearms, to Mexican cartels. For example, they come in the colors of the Mexican flag. There's a gun that's called El Jefe, or the chief. There's a suggestion that this marketing is targeted to cartels. So obviously the impact of this decision affects not only the gun manufacturers in particular, but other manufacturers of what could be called highly dangerous products. So think about prescription drugs or cigarettes. But in my view, the questions of proximate cause and even the aiding and abetting question in this case actually can be seen to apply to any run-of-the-mill negligence claim. So think, for example, if you're a manufacturer of cars, are you on notice that some of your customers may drive drunk and commit torts against other individuals? Is there a chain of causation in which you are a proximate cause of the injury to a plaintiff from a drunk driving accident if you know that some of your products will be used in that way? I also think of an analogy, and this is included in the briefing in the case as well, to the recent Twitter terrorism case that the court considered several terms ago, in which the argument was that because Twitter had created this social media platform that was then abused or misused by terrorist organizations to recruit and train and commit terrorist acts, that Twitter should be liable for those crimes. Of course, in that case, the Supreme Court sided with Twitter and said that the creation of the social media platform couldn't give rise to liability in that case. So it's possible the same type of analysis will apply to the gun manufacturers here, who are just putting a lawful product into the stream of commerce that is subsequently misused by criminals to commit violent acts. I think this case actually is a good counterexample to what Luke was saying earlier in the NVIDIA case and others about the Supreme Court's unwillingness to dig into the facts alleged in a complaint. This came up to the court on a motion to dismiss posture based on this question, whether liability is preempted by the federal statute. And I would expect an oral argument on March 4th, there will be questions in which justices have dived into particular paragraphs of the complaint to ask questions whether, this allegation or that one about marketing or the stream of commerce or alleged knowledge of the manufacturers can lead to liability in a circumstance like this. So it is, as I said at the outset, both a case about guns and a case not about guns, because anything that implicates criminal acts and questions of proximate cause is something that corporate defendants who face tort and negligence claims will be interested in following. So it'll be, I suspect it'll be a hot bench at oral argument, and I'm looking forward to March 4th.
Luke, Katie, any thoughts on this one before we move on?
Nothing for me other than I agree it's going to be a hot bench. It's an interesting issue.
Nothing to add on that one.
Okay, thanks. So the court granted certiorari on January 24th in Laboratory Corporation versus Davis. Barbara, are you surprised by that grant, and what's at stake in the case?
Yeah, so I don't think I'm surprised by this grant, given that there was an acknowledged circuit split on this question. It implicates Article 3, the scope of federal court's jurisdiction and standing. And the split is a little bit complicated. The courts of appeals have disagreed about whether this is a question they need to resolve at all. If so, whether it needs to be resolved at the class certification stage or at some point later in the case. All of that background just to say there are sort of several fractures in the jurisprudence among the lower courts here. And because it implicates federal jurisdiction, only the Supreme Court can resolve it. So I'm not, to answer your question directly, I'm not surprised by the grant. And I think it's an important case. So the question presented here as modified by the Supreme Court, and I'll point out the part where they modified it, is whether a federal court can certify a class action, this is the part they added, pursuant to Federal Rule of Civil Procedure 23B3, when some members of the proposed class lack Article 3 injury. So here's the background of the case. There was a group of legally blind plaintiffs who filed a putative class action in California against LabCorp, which is the diagnostic laboratory testing company where you can, go in and get your blood drawn to have it tested for whatever you need it tested for. LabCorp allows patients to check in for their visits either at a front desk, talking to a person directly online ahead of the appointment, or at a kiosk, a physical kiosk in the center, the appointment center, where you enter your information and check in. A blind person would need assistance to access that kiosk. So the plaintiffs argued that the self-service kiosks violated the Americans with Disabilities Act, and importantly, a California statute that provides significant statutory damages for even de minimis violations of the ADA. So that's why they filed in California, and this ended up in the Ninth Circuit. But the evidence in the case as it developed demonstrated that the legally blind patients actually preferred using the in-person or online check-in options, and the plaintiffs were unable to identify a plaintiff that had been denied laboratory service because of the presence of a self-service kiosk in the facility. So they tried to define their proposed class at the Rule 23 stage as any legally blind person who was exposed to a self-service kiosk. That is, anyone who walked into a facility where a kiosk like this was physically present, even if that person didn't know that the kiosk was there or would have preferred to or actually used a different type of check-in that's not the kiosk itself. So the district court in the Ninth Circuit, as the Ninth Circuit is wont to do, certified this class, even though it was undisputed that the proposed class concededly contained members who had no injury in fact and lacked Article 3 standing. Under the Ninth Circuit precedent, that is something you can do. You can certify a class notwithstanding that it contains members who lack standing. So as I said, there's a split among the courts of appeals on whether that is proper. And so I think it's important for the court to resolve that question. I think questions of Article 3 standing and the scope of federal courts' powers to resolve those sorts of issues are really important. In particular, I think that the question, including that WLF has highlighted whether a contrary ruling implicates the take care clause in circumstances like this, is an interesting one. So we'll have to see how the court decides.
Luke, Barbara noted that the court changed the question presented in this particular case. Is that a common thing for the court to do that? And is there any sort of rationale as to why they do that? Because they want to decide the case in a certain way?
It is not very common for them to do that. Usually it's up to the parties to frame the question presented, and that can have significant implications for the way the case is decided. Often, parties are savvy and they try to frame the QP in a way that's very beneficial to them, that bakes in some key assumptions for them. I think when the court intervenes, it's usually, as Barbara suggested, to add a potential off-ramp or some issue that one or more of the justices are interested in. So adding in the statutory issue in this case is a signal that there are some justices who think that might be a useful way to resolve the case rather than having to just rely on the constitutional principle. But it does happen every now and then. It's always a significant feature, and the court takes that very seriously. There was a case, I believe it was last term or 2 terms ago, the Warner Chapel case, where the court rewrote the question presented, which was about the application of the discovery rule to copyright disputes. And the petitioner tried to sort of re-argue the decision to rewrite the QP, and the court, in its opinion, made a note of pointing that out and saying, when we do this, it's for a reason, and you should take that seriously.
Again, if anybody has questions, you can please feel free to ask them in the Q&A box. Are there any cases pending argument that any of you are watching that we didn't discuss that you'd like to spend a moment on real quick?
So one case that I have my eye on is the Free Speech Coalition versus Paxton case from the Fifth Circuit. This is a case about a ban on access to pornography, a requirement that adults provide identifying information, like a driver's license, essentially, before accessing online pornography. And I think it's an interesting case for a number of reasons. It was argued in January, and it was very clear that the justices are attuned to the ways that changes in technology might implicate different standards in the First Amendment context. So there was a lot of discussion about whether cases that were decided 20 or 30 years ago, when the internet looked very different, really still have any bearing now when you have an internet ecosystem that is much easier for children to access, where in some cases, kids and teens are much more internet savvy than their parents are, and that defeats efforts to regulate access for kids and teens. So I think there's a baseline interesting First Amendment question. I think the actual question presented, which is about the standard of review, whether it's strict scrutiny or whether it's rational basis review, is also very interesting. We've seen the court, particularly in the Second Amendment context, question whether that sort of tiers of scrutiny approach makes sense anymore, or whether it should go toward a more history and tradition focused approach. And so I would be curious to see whether this case or a future case leads the court to rethink tiers of scrutiny across its jurisprudence in general. And I think we might get hints of that in the opinion in this case.
Katie, Barbara, anything you wanted to mention?
Yeah, so I'm following the Glossop versus Oklahoma case, not because it's a corporate issue or I have clients that are like subject to the death penalty, but just as a former Alito clerk, I always follow the death penalty docket to see when there will, and if there will be a shakeup on those sorts of decisions. This is an interesting case to me, in part because it's like the death penalty case that won't die. It's been to the Supreme Court before. The state is no longer defending the death sentence, so the court had to appoint Chris Michel to defend the decision from the Oklahoma criminal court below. And Justice Gorsuch is conflicted off of this case, so there are only 8 members of the court sitting, which means if they split 4-4, there's going to be a one-line summary affirmance in a death penalty case, which is something I can't imagine the court wants to do. They also added, speaking of QPs, they added a question presented when they granted this case on whether there's an adequate and independent state law ground, which is a little bit of a term of art in the criminal sphere, that would preclude review of the underlying constitutional issue presented by Glossop in all events. So I just think there are a lot of potential fractures here that could impact what, if anything, the court ultimately decides. And I think it'll be an interesting one to watch.
Thanks. Katie?
And we've been watching closely McLaughlin Chiropractic. It's not a super exciting case in any way, except for that it is kind of Loper Bright corner post adjacent, sort of follow on related to who gets to decide what a statute means and in what way. So the Hobbs Act has a provision in it that says that the FCC's interpretation, challenges to the FCC's interpretations of the Telecommunications Act must be filed in the Court of Appeals. And this case involves an FCC interpretation that's relevant to a dispute between private parties. And so the question is whether or not those private parties are bound by the FCC's interpretation of the Telecommunications Act, or whether or not they can separately functionally challenge the FCC's interpretation through private litigation. So pretty interesting Loper administrative law related subject matter, but one we're following.
Thanks, Katie. Are there any pending petitions for cert that any of you or your firms are working on, or ones that you're keeping an eye on that you think might be worth mentioning?
So I'm following, this is not a case I'm working on, but it's one I'm following just because I'm interested in it, the Speech First versus Witten petition. This is a case that raises the question whether a university, what's called bias response team, which is an official University of Indiana entity that solicits anonymous reports of bias, tracks them, investigates them, meets with alleged perpetrators, and can recommend formal discipline for college students related to alleged bias, whether that bias response team objectively chills a university student's free speech rights. So it's nominally about the free speech rights of college students, but I think given the executive orders we're seeing and corporate changes we're seeing on DEI policies, I think that case could have implications in the corporate sector, in the government sector, beyond just the free speech on college campuses. Fact basis in which it arises. It's been relisted a couple of times, so unclear whether the court will grant it or whether someone's just writing separately, but that's a petition I'm following.
Luke, Katie, anything you're following? Nope. Okay. So we'll sorry, Katie, do you want to mention something?
Just want to leave enough time for questions. We're following some, but I think we're running out of time, so I don't want to. No one wants to hear me talk too much anymore.
So my questions will end on sort of the elephant in the room, pun intended. The Trump administration's early actions have led to quite a bit of litigation, with some lawsuits posing some really interesting and novel constitutional questions. Luke, how long do you expect it will take these issues to sort of go through the courts? Some of them maybe to and end up at the justice's hands, and how might that impact how these sort of fights that are going on playing out?
Yeah. So I think the odds of some of these issues percolating up to the justices in the near term is virtual certainty. It could be as early as next week. I noted that the decision on the birthright citizenship order has been appealed to the Fourth Circuit. The First Circuit has also refused to pause the judge's decision, putting a stay on the decision about the funding freeze. And so these issues are getting teed up for the court. I think the court is going to be very interested in them. And I think the government is going to be very aggressive in trying to get them up. I imagine that part of the reason these executive orders were drafted the way they were is because the Justice Department and the White House want to tee these questions up for the court. They think they have a favorable court to consider them. And so it's in everyone's interest to try to get these up to the court as soon as possible.
Anybody else with thoughts on that one?
I think I'm sorry, go ahead, Katie.
No, go ahead.
I was going to say, a concern I always have when you have stories about like a rush to get cases up to the court is, part of the advantage of a little bit of a slower Article 3 process is you make sure that there aren't vehicle problems like standing issues and jurisdictional issues and questions of who decides that would normally get aired out in the course of litigation, but when things go up on an emergency posture, aren't briefed and argued, the Supreme Court takes a case or hears a motion, all of a sudden turns around and has to dig it. So I would keep my eye on those types of arguments going forward, just to make sure that if and when the court decides these questions, they actually get to decide them.
And I was just going to say, I anticipate a ton of pressure on that on that emergency docket, which I know the Supreme Court doesn't like for some of the same reasons. So it's going to be interesting to see how the court handles that.
So do any of you expect that the question of when a president has the authority to dismiss an independent agency's commissioner, which sort of came up to some extent in the Axon case and the SEC case last term, but it didn't quite get to that far. But certainly the issues might be presented directly here. Do any of you see the Humphreys executor issue being looked at in the near term by the court?
I think that is likely to come up. That seems less like an emergency issue to me and one that could percolate through the system. But I would imagine, I believe there was a case filed on the firing of the inspectors general just yesterday. And so there will be litigation on those issues. And there's obviously interest in the court on them as well.
Anybody else want to weigh in on that one?
I agree. There are likely folks on the court interested in what is this independent agency that you're speaking of. So I think, yes, that'll be litigated.
Well, seeing as we have no questions from our audience, I guess we answered all of them. Wanted to thank all of our participants today for taking the time to grace us with their presence and their insights, and thank everyone for joining us today as attendees as well. This will be available as an on-demand video later on in the day today if you know of anyone who might want to watch it. Once you sign off, there'll be a very brief 5-question survey that we really appreciate it that you take a few moments to take as well. If you thought that this was a good program, we'd definitely like to hear about that. And again, thank you, Luke, Katie, and Barbara for joining us today.